Welcome to video 9, Trial. In the last video I taught you how to implement a pretrial strategy by plea bargaining and raising pretrial motions to try to have your case resolved before trial while increasing your chances of winning at trial. In this video I'll teach you how to represent yourself during trial to have the best chance of being found not guilty while protecting the trial record for an appeal just in case the trial judge finds you guilty after trial. Remember though, you can usually begin fighting your case without ever stepping foot in a courtroom by starting with a trial by written declaration like the one found on the LAWintel website. And your court battle could begin and end with a trip to the mailbox. However, if you were already found guilty in your trial by declaration and requested a new trial in person, called a trial de novo, or if you skipped the trial by declaration and set your matter for bench trial, then this video will teach you what to wear, where to sit, and what to say when you get to court. You'll also learn how to make an opening statement, raise objections, conduct a cross-examination, testify on your own defense, and make a persuasive closing argument. By dressing professionally, you'll make a statement that you take your case seriously and respect the court. By dressing in business clothes like you'd wear to an important job interview, like long dark-colored pants and a dress shirt, or a conservative length dress for women, you'll be sure to garner more respect from the judge. You'll also set yourself apart from the horde of defendants who do not dress properly. Although you don't need to wear a suit, you definitely should not wear a hat, shorts, tank tops, jeans, or anything too sexy or costumish like Western wear. When your name is called for trial, you should listen carefully to the bailiff's or judge's instructions, as you may be sent to a different courtroom or be asked to start your trial immediately. Before trial, you should have already checked to be sure that the court is recording the proceedings. Although there won't be a jury in your case because you don't have a right to a jury for traffic infractions, the defense table is usually the table furthest from the jury box. You can also find the defense table by choosing the table opposite from where the officer is standing. And remember, as intimidating as the judge and courtroom may be, this is your day, your trial, and your rights that are being exercised, so stand up tall and proud. Everyone is there to work for you, including the judge. If you have any pretrial motions in limine or a motion to recuse the judge, then now is the time to bring these motions to the court's attention. You should always stand up tall when speaking to the judge, even if the officer or other defendants before you remain sitting. This will make your arguments seem more persuasive, and it will help you project your voice across the courtroom. Before the prosecution begins, you have a right to make an opening statement to the judge in order to get him or her thinking about your defense before the prosecution puts on its case. The officer would normally go first, but he or she will usually not have any opening statement prepared. Your opening statement should simply be your story of the case by summarizing the evidence that you anticipate will be presented. During opening, you should describe the reasons why the court should give little weight to the prosecution's evidence, and if you plan to testify or introduce your own evidence, then you can tell the story of what actually happened in your own words. But be sure not to testify at this time by prefacing your story with the words, "The evidence will show." After your opening statement, the prosecution will put on its case. This is the time for you to make objections, but not to testify. Objections can help you exclude evidence during trial, but they are also important to protect your trial record for an appeal. A list of possible objections can be found in PDF number 9. Before objecting, be sure to listen carefully to exactly what the officer says, and it is a good idea to take notes of everything he or she says so you can identify omissions and attack any mistakes. And as soon as the officer tries to introduce improper testimony or evidence, you must stop him by standing up and declaring objection. But be sure to also state the specific grounds for your objection, like lack of foundation or hearsay. If you do not say those words, then you cannot appeal a bad ruling on your objection by the judge. While the officer is finishing his case, you should be scanning your checklist of elements. Be sure to check if the officer failed to prove any single element of the prosecution's case beyond a reasonable doubt, like identity. Then, if the officer didn't prove every required element beyond a reasonable doubt, then when he or she rests their case, you should stand up and make an oral motion to dismiss on the ground that the prosecution failed to prove its case beyond a reasonable doubt, precluding any need for you to put on a defense. If the judge then tries to fix the officer's mistakes by asking him or her questions to help prove the missing elements, then be sure to object to the judge acting like an agent for the prosecution by trying to reopen the state's case against you after it was already closed. Be sure to object boldly and persuasively, but also politely by quickly stating that your objection is for the record on appeal. This shows that you respect his decision-making authority, but that you are acting in an effort to protect the record for appeal, which will make him think twice before ruling against you. No matter how unfair you think a ruling may be, never show your anger or interrupt the judge, or the consequences can be more than you bargained for. You could even be held in contempt. But if you really feel like the judge is treating you unfairly, instead of raising your voice, you should politely say the words, "with all due respect." These words should only be used when you have no other polite option to force him or her to allow you to speak in order to protect your record for appeal. After the prosecution rests, you'll have the right to ask questions, called cross-examination. You should tactfully plan your questions well in advance using the samples in PDF number 9 to help you, and be sure to design them to control the witness by asking only leading questions to elicit yes or no answers. If you ask the officer an open-ended question, he'll have the chance to testify in the form of a narrative where he may use the opportunity to clean up weaknesses from his earlier testimony. When you finish your questions, it will be your turn to testify. You still have a right to remain silent, but you should plan to testify if you are factually innocent or if you have any defenses that require your testimony, like the defenses of entrapment and necessity. Be sure to bring your LAWintel PDF checklists with you to court so you can be sure you are testifying to all the necessary elements to prove your defense theory of the case. The closing argument is your time to summarize your theory of the case based on the actual evidence introduced at trial. You should keep it short and logical by focusing on the prosecution's lack of evidence in order to create reasonable doubt. Or you can argue instead that the evidence actually proved your defense theory and then ask for an acquittal. The judge will usually enter the verdict right away, and if you win it will be over. If you're found guilty, then he or she will impose your sentence. There are few greater joys than the thrill of victory after preparing for and winning a traffic trial where the odds are stacked against you from the start. This concludes video number 9, Trial, where you learned where to sit, what to say, as well as how to make an opening statement, make objections, conduct cross-examination, testify in your own defense, and give a persuasive closing argument. Be sure to read PDF number 9 for additional tips and information. Thank you for learning with LAWintel, where you'll always find intelligent legal resources. I wish you the best of luck with your case. Please be sure to let us know how your case turns out and how we can improve this course for others who would like to fight their cases too.